Welcome to today's case breakdown, and let me warn you, this one has it all. Multiple assault charges, a protective order, repeated bond violations, and a defendant who seems to think the law will keep giving him chance after chance. But as you'll see, the judge in this courtroom has finally had enough. We're about to witness how leniency turns into frustration and how a defendant's repeated defiance can backfire spectacularly. Pay close attention to the details, the timeline, the repeated offenses, the shifting excuses, because this is not just about one man's mistakes, but about how the justice system struggles when offenders refuse to change. Stick around because some of the twists you're about to hear will leave you questioning whether anyone in this case truly learned their lesson.
Violation of a bond condition.
That's correct, Your Honor. That was filed as a to-be warrant.
I don't know anything about the cases, and I haven't spoken to him in a very long time. Does he speak English?
He does, yes, sir.
Great. I'm going to have him. Does he bring him up? He is not made bond on the felony case, so.
That's correct.
Good morning, Mr. Mendoza.
Morning, sir.
Sir, you're charged with 2 cases with us. You were charged with assault of a family member. You're now also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That allegation kicks it up to a Class A, so you're also facing a year in jail. And
Here's where it gets serious. The judge lays out the charges: assault of a family member, failure to identify as a fugitive, and the weight of potential jail time and fines. Notice how he emphasizes that the case is already a year old. This tells us something critical. Delays, resets, and excuses have already clogged up the process. The defendant isn't walking into this courtroom fresh. He's carrying baggage, and that baggage is legal dynamite. Do you think at this point he's still taking it seriously, or is he betting the court will cut him slack again?
In the nose and mouth, causing her pain and visible injury. Officer observed the complaining witness to have a swollen bottom lip with a small laceration, and she was holding a bloody towel that
This moment paints the human side of the crime. The swollen lip, a bloody towel, visible pain. These aren't just words on paper. They're the evidence that prosecutors will lean on to argue. This is not a minor dispute, but a violent assault. Remember, in family violence cases, the credibility of the victim often hinges on physical evidence. Here, the officer's observation backs her story. What do you think? Does this sound like a one-time lapse of judgment, or a dangerous pattern starting to unfold?
I didn't hear any of that.
Officer, on June 4th, 2024, officer responded to a disturbance call and spoke with the complaining witness. Complaining witness stated that her husband threw her against the wall after she called his mom to complain of his behavior, and then she stated that she had a...
Now things escalate. The victim reveals there's already a protective order in place. That means the defendant has not only committed violence, but has ignored a direct court order meant to protect his partner. This is a massive red flag in domestic violence cases. Judges see protective order violations as direct challenges to the authority of the court. It's no longer about just the couple fighting. It's about whether the system itself is being defied. This is where the courtroom tension starts rising.
I believe so. Officer spoke to the female on scene. Officer stated the female was not answering questions due to not wanting to get the defendant in trouble. Officer observed the name and date of birth the defendant provided to officers were not coming through a TCIC search. Officers advised the defendant that if he does not have proper name and date of birth, he'll be charged with failure to identify. The defendant then confessed and provided his real name and date of birth. The defendant stated he did not.
Did you catch that? The defendant gave officers a fake name and date of birth, only to backtrack when they pressed him. Think about that. He knew he had outstanding warrants, so instead of facing the consequences, he tried to outsmart the system. But here's the problem. Lying to law enforcement isn't just a bad idea, it's a crime on its own. And every time he tries to dodge responsibility, the hole he's in just gets deeper. Have you ever noticed how people who try to escape accountability often end up with worse outcomes than if they had just told the truth?
Continue to give you chance after chance. You continue to you just don't give a shice about bond conditions, man. Really?
This is the breaking point. The judge is visibly fed up, pointing out that this defendant has been given bond after bond, only to keep running, hiding, or reoffending. Listen to the language. You don't give a damn about bond conditions. That's a powerful statement from the bench, because it shows the judge no longer trusts him. In the courtroom, trust is currency. Lose it, and your chances for leniency evaporate. What would you do if you were the judge here? Keep giving chances, or finally slam the brakes?
Complainant advised that the reason that she had a bloody nose is because she does drugs and was doing cocaine. He did have the PR bond. The VPO was a 2B warrant, so he wasn't given bond and didn't come on that one.
Yeah, but he had a warrant out for both. Apparently knew about them. So,
Well, it didn't say that he knew about the felony warrant.
Well, I don't know, but
You can't make believe that he knew.
I mean, I can, if you want a bond reduction, I'm willing to give you a bond reduction. I'm not gonna give you another PR bond, dude. Really, I'm just, no more PR bonds. And you know, you've got these cases out, just, you can't out of sight, out of mind. And the only reason you're here now is because you got into another damn argument. So, Mr. Mendoza, I am now issuing another protective order on this case. And I want you to understand that the Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold someone at zero bond. This is now one of those cases. If you continue to violate protective orders, we can have a hearing to hold you at no bond.
No means no. The judge is crystal clear. Every phone call is recorded. Every violation leaves a paper trail, and the court is watching closely. This isn't just a warning. It's the last warning. Protective orders aren't suggestions. They're lifelines for victims, and when defendants ignore them, judges have no choice but to escalate. You can almost hear the frustration in the judge's voice. He's tired of this revolving door. And honestly, who can blame him?
If you want a bond reduction, I'm happy to give it to you, but I'm not gonna just continue to give homeboy PR bond after PR bond after PR bond. Just not, you know?
Would the court be willing to reduce the bonds to $1,000?
I'll cut it in half.
Here's an interesting twist. Despite everything, the judge cuts the bond in half, $2,500 instead of the full amount. Why? Because judges still have to balance punishment with fairness, making sure bonds aren't excessive. But make no mistake, this reduction is not a gift. It comes with strict conditions. No weapons, no drugs, no contact. It's almost like the court is saying, fine, here's one last rope. But if you hang yourself with it, that's on you. Would you have reduced the bond here or held firm?
All I need you to do is file the MOA, because we'll have him, pre-trial is going to, make sure that you're in compliance. All right, Mr. Mendoza, so what we'll do is the felony case is set for June. So what we'll do is, I don't like to set the people for more than 30 days, so you just don't get forgotten about. We can set you for 30 days, come back, and then, go from there.
Thank you.
Okay? All right.
Maybe.
Yes, ma'am. Thanks.
I'm here today on,
Now we shift gears. A new defendant enters, this time with a failed drug test for THC. Notice how the courtroom dynamic changes. The issue here isn't violence, it's responsibility. The judge reminds him that it doesn't matter how young or old you are. If you're breaking the law, you're facing consequences. This is a subtle but important lesson. Courtrooms don't just punish, they try to course correct. But will this young man take the warning seriously or slide further down the path of repeat offenses?
You now stand charged with another burglary of a motor vehicle. So they now have you on 2 charges of burglary of motor vehicle. I'm telling you that I'm going to do everything in my power to protect my public. I don't care how old you are. I don't care how young you are. You go out there, you start acting a fool. It's not going to go well for you. Do you understand? I just set someone's bond now at nearly $30,000 because they're out there running amok. Don't do it. I'm going to test you 50 days from today. If I find that you continue to use, it's not going to go well for you. Do you understand? We need to do probable cause on the new B&B because we haven't done it. So do you mind? On the new case,
is that failure to ID?
no. So there is a failure to ID. There's one BMV, and I guess later on in the day goes out and allegedly has another BMV.
Yes, Your Honor.
Okay.
On April 7th, 2020.
This burglary case is textbook car alarms, suspects in black stolen property found in the defendant's possession. The key fob is the smoking gun. Notice how airtight the evidence is. This isn't circumstantial, it's direct. Judges love evidence that ties suspects to the scene beyond reasonable doubt. And here, with the stolen key fob on him, the defense has very little room to maneuver. Ever wonder why so many burglary cases end in plea deals instead of trials? It's because the evidence is usually this concrete.
Because he's got someone else's key fob.
Yes, Your Honor.
Okay.
Then he was identified by mobile AFIS.
I think I need to get a title to that third one.
We'll attach you to it now. Yeah. So do you want to file another one because he has a new case?
Your
The
Honor.
one in Fort 16?
Yeah. Or I guess we need to get it over here. You want to do a transfer? Okay. Yeah. You
I
want to?
was going to say, on mine, it was still showing.
Yes. I don't want you out in the middle of the night. I'm going to put a monitor on your ankle so I know where you are at all times. I don't want you to have any contact with the complaining witnesses in this case, and I don't want you to go anywhere where they live. You pick up a fourth case, I'm going to go haywire. Do you understand? What are you doing with yourself these days?
This is fascinating. The judge isn't just punishing, he's parenting. By ordering the young defendant to get a job or go back to school, the court is basically saying, idle hands are the devil's workshop. It's tough love in action. Some might see this as overstepping, but think about it. Without structure, this defendant is likely to reoffend. Do you think judges should have the authority to enforce lifestyle changes like this, or should they strictly stick to legal punishment?
I'm bringing you back in 2 weeks, and I want to see what you have done to get a job. If you have done nothing, it's not going to go well for you. Do you understand?
That's not.
Do you have an ID? Okay, I want you to start going and applying for as many jobs as you can, or you get back into school. While these cases are open, military is not going to take you. I don't think. If that's something that you want to go do, that would be great, because that would give you great structure, which you probably really need. I mean, the military would be a fantastic idea for you that would really, could potentially put you on a career path that could just lead you to the clouds, really. What you're doing now, you're charged with 2 counts of burglary. You know what that'll do to your career?
So, what did we learn today? In one courtroom session, we saw 2 very different stories. One of repeated violence and broken trust, and another of youth and poor decisions spiraling toward disaster. In both cases, the judge balanced fairness with firmness, offering chances but drawing clear lines in the sand. These rulings remind us that the justice system isn't just about punishment, it's about accountability, protection, and sometimes tough love. Now I want to hear from you. Were the judges too lenient, or did they strike the right balance? Drop your thoughts in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share this breakdown with your friends, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.